Attention, Canadians. Feel disconnected from our current political system? Join the Powershift to freedom movement by the Canadian People's Union and be part of a bold vision for Canada's future. It's time to shift the political power to its rightful owners, the Canadian citizens and Indigenous peoples of Canada. Dive into our history, understand the need for change, and embark on the quest for true democracy. Are you concerned about our nation's commitment to human rights and self-governance? The Powershift to Freedom aligns with vital treaties and international laws, enabling us to claim our rightful place as collective head of state. We advocate replacing our partocracy system with a true democracy to ensure your voice counts more than party interests. When our national collective civil and political rights are respected, your influence on policies will be direct and impactful. Join us on this noble struggle to make every Canadian and Indigenous peoples a meaningful participant in our future. People 15 years old and over can sign the Convention of Consent and unite for our rights in the Constitution. Ready to be part of this transformative movement? Visit thecpu.ca for more details. Embrace the change and shape our future.
The way that it is set up, it's not like a real referendum, like a normal referendum that you'd see, the ones that they try to push onto us. But this year, because of our rights, and I explain this in here, I actually make the argument here. Okay, this is like our rights and the court case with it and the proof. So everybody, if anybody wants to argue this, they can argue with the video that I did the other day. The explainer is going to be posted in here. They can listen to the explainer video that I did in regards to a 170 page presentation that I put together where I connect all the dots, and especially of the last 4 years towards the end, and where they're trying to bring us to planet-wise in regards to transhumanism agenda and placing us, the people, as their petri dish that they can dissect in every which way they can. They're trying to play God. So this is the people as the collective head of state, constitutional referendum that we did not get finalized in 1982. So when they say Canada repatriated the Constitution, you will see the proof within that Canada was told no in 1982 because they did not receive a referendum of the people. So the Queen remained the Queen for the last 40, and now King, for the last 42 years, who had the right to take over our complete governance, this country, because they hold the title of head of state. They hold the title of corporation sole and corporate aggregate. So now I've put everything together. And this document here, as a people, we have the right to choose the form of government that we want. We have the right to choose how we're doing our referendum, what goes into our referendum. And the minute that we reach full majority, then, they, by law, if the law was followed. And so now we have to ensure that the law gets followed. That's another job that we have. And to be able to make everybody understand why they want their freedom, why it was taken away from them, for what reasons, and how can they get it back? So, and how can we make sure we keep that freedom? So all of these answers are in here, okay? So food for thought. An oxymoron is when you claim to decolonize a country and its people, then keep the colonizer as the head of state. Are you ready to be part of this historical people's referendum for Canadians and Indigenous peoples? For the sake of our country, please read and e-sign the referendum below. So it's about what we all agree together to sign. and in which format. And then the Canadian government, no matter who is going to be there, will have to follow. So people, the buck stops here today. But that depends on you. Okay. So now this here is the top part of the web page. And now the referendum itself begins here. The people as the collective head of state, constitutional referendum 1982-2024, binding living document, because this is going to last as long as we need the signatures. Now, what I created in 2014, along with a friend, was the Citizens Convention of Consent to the right to our civil and political rights to collective self-determination and self-governance, and the right to a direct democracy system of a type of direct democracy system of governance. So we started that work, but the Convention of Consent that everybody signed was proof that people want the change, that people want to stand up for what we are initiating today. So everybody who signed the Convention of Consent is invited to sign this one. Although I do combine the other two. The other two only ask for specific. This asks for the rest. So because of what needs to happen today. What they're trying to do in government, before we go any further, is to bring out a law that once royal assent is given, then elections will be held, whether we need them or not, only on certain dates and certain years, like every so many years. Because of that, once it becomes law, we are not going to be able to remove anybody. We need to stop this. It is unconstitutional. And everything that the government has done since 1982 is unconstitutional. Okay. So our lawyers, our Supreme Court justices, and all the justices across Canada, the bar associations in every province, all the premiers, all the parliamentarians, all the senators will get an education, whether they want it or not, because they won't be able to prove me wrong once and for all. So I signed this referendum on November 3rd to test it. And it says, referendum objective. The Canadian government has had an obligation to hold a nationwide constitutional referendum for its citizens, predating the Canada Act 1982 request by the Parliament and Senate to the United Kingdom, which only partially patriated the Constitution on April 17th, 1982. The UK Commonwealth Foreign Affairs stated that due to the government not having held a referendum prior to the constitutional patriation from the UK, the Imperial Parliament could not proceed as Trudeau had hoped. And here I'm talking about Pierre Elliott Trudeau. Okay, so they couldn't proceed as he had hoped with the patriation. Instead, Pierre Elliott Trudeau was obliged to accept post-patriation amendments that have yet to be fulfilled 42 years later, and kept it from the people to this day. The political parties knew about this. Every government since 1982 knew about this. The Conservatives know about this. Have they been telling you? No. Why? Because they need to maintain control over the people so that they can decide what happens with our natural resources. In a decolonization process, the resources come back to the people. So today, this is what we are doing. So now it says constitutional amendments, and this is from the United Kingdom and the Commonwealth Foreign Affairs. Constitutional amendments can only be accepted by the Imperial Parliament in accordance with the wishes of the people of the Dominion as a whole, not at either federal or provincial bidding. The premiers have no power, and neither does the Prime Minister without the people? And if you want to argue that, I suggest you read the Kershaw Report, Statement from the Commonwealth Foreign Affairs Committee, pages 33 and 34. And you're going to read some very shocking information in there, and especially for the Indigenous peoples and Canadians. Now, decolonization / patriation, and this is how they tried to confuse everybody by using the word patriation instead of decolonization. So decolonization, patriation of the 1982 constitutional coup d'etat should have given complete independence and full power to the people to choose what we decide together in regards to our own country. This was never finalized and served as a parliamentary and provincial inside coup d'etat against the peoples of Canada. This coup d'etat was further extended as of April 17, 1997, to Her Majesty Queen Elizabeth II, and now to His Majesty King Charles III as Canada's head of state. Therefore, the Canadian people hold the prerogative to rectify the purported 1982 coup d'etat, which allegedly undermined the constitutional patriation of the Canada Act 1982, orchestrated by Pierre Elliott Trudeau's Liberal government, Parliament, Senate, and the provincial premiers. They were all told before the signing of the Constitution here that they needed the people to have a full referendum, and that was not done, and they lied since. The Canadian government enacted the legislation without securing a mandatory referendum from affected Canadians regarding keeping the monarchy or the Canada Act 1982. We could have decided what we wanted in there and what we wanted to do. Because we were not given a referendum on these issues and on how we wanted to govern ourselves, the Canada Act 1982 was enforced without our consent, thus maintaining the Crown and Parliament's supremacy over the people. And it's not the Crown and Parliament supremacy of only Canada, it's of the UK. Foreseeing democracy, now when we're looking at parliamentary democracy, which is what we have, the international have determined that foreseeing democracy, parliamentary democracy, as the only legitimate outcome cannot truly be considered a free act of self-determination. So because the people were all happy about the Constitution and everything else, the government tried to say, well, the people want this, and look, they're by the millions at Parliament on April 17, 1982. So this is how they passed it on. But the international level, considering other countries, tried to use that same excuse. It didn't work. It did not work. Because self-determination needs to come from the people, not because the government says, oh, look, they're so happy. No, they're just being stupid because they don't have the information. They're not stupid because they're stupid. They're stupid because of the missing information that the government deliberately withheld. So there's nothing derogative about being stupid, just being like deaf, blind, and dumb, you know. If you're covered and you don't hear anything and you don't see anything and they don't tell you anything, how are you supposed to know? So in a statement made during the parliamentary meetings, Sir B. Brain stated that the Canada Bill sent to the UK by the Canadian government, that certain parts of the Charter breached the international agreements that both Canada and the UK had ratified. There is much more shocking information within the Hansards that indicates that a coup d'etat was committed against us by our own government and by every other government for the past 42 years since. The evidence suggests a systemic undermining of democratic processes by government authorities over the past 4 decades. Has it been long enough? And this is why this referendum is the referendum that we needed to have since 1982, that we are now going to have. So here you can find the link here in order to see exactly what was said. The link is here and you can download the file. And happy reading, because I'm telling you, it's one of the most interesting documents I've ever read. Now, what does it say? I want to show you as an example. Canada Bill Hansard, UK, the House of Commons, and the debate, the 17th of February, 1982. So one of the ministers says, my honorable friend, the member of, not ministers, but an MP, says, friend of a member of Essex Southeast, Sir B. Brain, has shown clearly and cogently how certain parts of the Charter offend and infringe two international agreements to which we are signatories, Article 17 of the Universal Declaration of Human Rights and Articles 1 and 27 of the International Covenant on Civil and Political Rights. What I will be reading to you now is the fact that when Canada signed on to those covenants and treaties and agreements, when they sign at the international level, these are binding and they're automatic in our constitutions. Automatic. Canada has denied this fact for 42 years. So our rights have been abused systemically by every government since 1982. Well, actually, since 1976, because in 1976, Canada and the UK both signed it. And because we're still a colony of the UK back in 1982, and now still to this day, the UK signed it and they're liable as well. Okay. So some of us may not wish to be signatories to those agreements, but we are bound by them. So long as we choose to be feted by those covenants, they remain shackles upon the house, and we should recoil from any legislation that infringes upon them. To do otherwise would be dishonorable, even disreputable. It is, of course, true that Canada is also a signatory to both agreements, but whether she decides to infringe them is not a matter for us. Two wrongs cannot make it right. So we're not going to go against it. And if Canada wants to, well, that's tough luck for them. Okay, basically what's being said. The Indian nations are justified in questioning the bona fides. And then he continues to say, the Indian nations are justified in questioning the bona fides of the Canadian Prime Minister. I say that with great regret. As long ago as 1969, he spoke in Vancouver about the need to bring an end the historic treaty rights of the Indian peoples, and spoke of how in due course those rights must be extinguished. He refuses even now to sit at the conference table to discuss and define what those rights are. He will not do so until the new Constitution of Canada is established. And at that stage, he will have the power to override the Indians. That is our dilemma. We do not wish to offend Canada, but if we pass the bill in its present form, we shall infringe two international agreements, and at that same time disregard the rights of the Indian nations given under 83 treaties between them and the British sovereign. For that reason, I shall find it difficult to support the bill. 1, this referendum is a legally binding living agreement between the signatories, Canadians, to achieve the required 51% of Canadians being in agreement with this referendum within a minimum of 7 provinces to reach a fair majority of our citizens. This referendum is to be combined in conjunction with the Indigenous and Civil Unified Sovereign Enactment, Citizens' Convention of Consent to collective self-determination and self-governance within a combined direct democracy system of governance. Dishonor of the dignity of the Crown, abuse of power, and breach of trust. No confidence in the Crown, the Canadian government, Parliament, provincial legislatures, and Senate. And why is this here? It's so that there's no mistake. No mistake, because right now, the Crown has a fiduciary duty to Canadian citizens and Indigenous nations to make sure that this comes through. And at the international level, countries are bound to assist us. Our governments are bound to assist us in our decolonization process. Whether they choose to or not, time will tell, but we are proceeding no matter what, and another country can back us up. Now, the public has grown increasingly distrustful of the government, legislators, and the Senate due to alleged corruption, disregard for citizens' rights, and the mishandling of public funds and health care. The Governor General had the full rights to remove Justin Trudeau the minute allegations of corruption were made. A prime minister can be removed, even if he has the support of the House. His action harms the dignity of the Crown. If the people or the Governor General, GG, have lost confidence, or if he has breached the constitutional order. The Australian Governor General dismissed the Prime Minister, who had full support of the House in 1975, by using the personal reserve power of the Crown, of which the Queen was aware of, but only after the fact, and was pleased with his judgment in preserving the Crown in Australia. So this happened in Australia in 1975. Now, please see Palace Letters. So if you go here, you'll be able to download the link. Well, it'll bring you to the link where you can download all of the documents that were released in 2020 in Australia regarding the reserved personal powers of the Governor General and the Crown. Constitutional lawyers will have to revise all the private letters of the Queen and Governor Generals of the realms in their entirety. Otherwise, everything they think to be correct regarding the reserved powers of the Crown will be proven to be wrong. Okay, and here's again the link. So whereas we, the Canadian citizens, find it necessary to move forward with this referendum to preserve the life of our nation in all aspects, given the current state of government and the persistent misuse of authority, abuse of power, as well as the continued disregard for our fundamental rights. The will of the people as a whole. It is undeniable that any people entitled to the right to self-determination must exercise it freely, whether through plebiscite, referendum, or some other agreed procedure. We as a people have the right to proceed with this referendum as long as the majority of Canadian citizens agree to this referendum format and all it encompasses as our agreed upon procedure of choice and free expression by signing this document. Now, here's the quote. Representativeness from the international, representativeness of the government in the context of the right to self-determination is that the government and the system of government is not imposed on the populace of a state, but that it is based on the consent or assented by the population, and in that sense is representative of the will of the people, regardless of the forms or methods by which the consent or assent is freely expressed. Checkmate. Okay. Now, UK colonization of Canada, 1867 to 2024. Governance in Canada has always been imposed on the people, such as we have seen in 1982, with the misleading partial decolonization / patriation of the British North America Act 1867 and Canada Act 1982. A people cannot give free expression when the truth is inundated through lies, cover-ups, and omissions by the very governments they entrust. Because of these lies and omissions, Canadians and the Indigenous peoples are still a constitutional colony of the Imperial Crown and Parliament, whereas the United Kingdom Parliament still holds the only authority to amend our Constitution Act 1867 and the Canada Act 1982 Charter of Rights and Freedoms. Now, when Justin Trudeau said that he had a loophole that he can use with the provinces and to change the Constitution, he's playing with a draft copy. And I've proven that in my video, showed you the proof that we are still, that even the UK is still making corrections to our British North America Act because it is the legally enforced document. the Canada Act here, the Constitution 1867 is a working copy that where we can use to change some things and see what we want to do with our Constitution and what we want to have in it. Mind you, it was only to be done for 15 years. Now it's been done for 42. Okay. So now, form of government. International law does not impose a restriction on the people's choice as to the form of government, as long as the exercise of that choice takes place in a free manner, without any external influence or coercion. Neither does it say that a government is supreme and has the final say over a people. Therefore, we, the undersigned Canadian citizens, freely agree to initiate our collective and personal civil and political rights, including all other rights we possess, to hold this referendum by we, the peoples of Canada, without the interference or hindrance by the Canadian federal, provincial, or municipal governments or the courts, through our recognized legal rights, binding on Canada and the United Kingdom too. Formally remove King Charles III as Canada's head of state, constituting a collective sovereign people as a whole, as the collective head of state within Canada, being the lawful, collective, and legal holders of its collective corporation soul and corporation aggregates, and transferring to the people all powers of the Crown, including military and personal reserve powers, which are prerogatives, etc. Elevating Canadians from a neo-colonial parliamentary democracy system to a combined parliamentary and direct democracy system of governance in Canada within the required amount of time necessary to implement the changes. 5, correcting our Constitution as need be, removing unconstitutional laws, neglecting our rights and those made in errors and omissions. 6, establish the rights of the people to veto legislation prior to royal assent by the Governor General and Lieutenant Governors, and then but then we can decide how many people have to vote on the number of votes given to be determined. So that could come at a later date. It's no biggie. Okay. So honoring Indigenous treaty rights and responsibilities, maintaining and safeguarding all Indigenous treaties, rights, governance, responsibilities, and obligations held in perpetuity to them that were transferred to Canada from the Crown, honoring Canadian and Indigenous peoples on each side of the Truro, Wampum, and Silver Covenant Chain treaties by creating seats for the Indigenous peoples in Parliament regarding Indigenous issues. Sorry. Just going to take a drink here. We further undertake constitutional initiatives too, placing the Governor General as the Canadian people's representative under the complete authority of the people as head of state. And that's for the transition. And then require that the offices of the Governor General, the Attorney General, and Lieutenant Governors be chosen through the electoral process. So they'll have to run for office, okay? And then we vote who is going to be the best to represent us. But none of them have final say. We have final say. They're just the mouthpieces. So, and then they'll be guided as to what they can do and cannot do. So now we, the undersigned, agree that for the sake of preserving the life of our nation, our economy, our children, and our future, hereby formally notify the Governor General that we do not support the numerous dishonorable and disreputable breaches of trust committed by Parliament and legislatures. 2, the questionable financial abuse of money votes for $202.75 billion of taxpayer funds voted in by Parliament for the year 2024-2025. 3, policy mismanagement and illicit acts through the creation of unconstitutional bills that override the international binding agreements the Parliament has dishonored by criminally disregarding them since 1976. And 4, the funding of wars and genocide that is subjecting all Canadians at risk from internal and external retaliation without our consent. This, people, okay, needs to happen because, why? All of the laws that they have created, especially in the last 4 years, are all unconstitutional, based on international law rights of the Canadian citizens, and every court case that's been had and lost since has to be reverted in regards to a huge error and fraud committed by the Canadian government, the parliamentarians, the Senate, the provincial leaders, all of the provinces, and all of the municipalities, and the RCMP and the police across Canada that issued tickets for the wrong reasons because they had no right to. And we have further proof to show you. My presentation is 170 pages. You're not going to see that today. Here, this is about this and what we need to do in the now. And it needs to happen. So, FYI, for your information, Crown responsibility and liability. The responsibility of the head of state is to maintain the honor and dignity of the Crown and not allow the further demise of the Crown through the actions of our own politicians and government, who have become the real threat to the national security and stability of our nation. Adhering to the rule of law, international law, and human rights is essential, as maintaining a functional government is crucial to avoid plunging the country into further turmoil. With the Statutes of Rome, command responsibility and failure to act, responsibility of civilian superiors. Okay? They need to pay attention to this. Canada removed all immunity from Canadian officials. The only immunity that the government right now, the officials, the parliamentarians can claim in Parliament is the parliamentary immunity, but they're not immune from their acts in law, internationally or even nationally, because even Canada signed the Corruptions Acts, and many more documents that will that could take them to task, that we can use here and even charge them with this own country against those documents. So now, one, by the Canadian government and the provinces implementing the provincial emergency measures, and then the unconstitutional, illegal Emergency Measures Act, without consideration to our non-derogation of rights, placed International Bill of Human Rights protected Canadian convoy protesters, because the Canadian convoy was protected under the International Bill of Human Rights. So by placing Canadians in an armed conflict with the RCMP and police, these may qualify for internal crimes against humanity. And the Minister of Defense Medical Countermeasures Consortium within our healthcare system, connected to other countries, could place all Canadian military, medical personnel, and parliamentarians, including the Governor General and the head of state, King Charles III, in jeopardy of international law crimes against humanity and human rights abuses due to the consortium's action. Here, I'm talking about the last 4 years. And that's in my presentation on the other side of the proof that we have about a false pandemic. 3, the Canada, UK, Australia, and USA consortium's actions include the creation, along with Canada's dual use potential, this is what they call it, gain of function viruses since 2001. And here, I'm not going to click on this, but you'll be able to see the viruses that Canada has created since 2001. Where does SARS come from? We'd have to get that investigated. All the hoopla about Manitoba and the research lab. Where does SARS-CoV-2 come from? Was it really China? No. Note, A hierarchical superior in a non-military relationship with subordinates is criminally responsible for crimes within the jurisdiction of the ICC, the International Criminal Court, committed by subordinates under his effective authority and control where he knew or consciously disregarded information which clearly indicated that the subordinates were committing or about to commit such crimes. I'm going back to early 2020 here. The crimes concerned activities that were within his effective responsibility and control, and he failed to take all necessary and reasonable measures within his power to prevent or repress their commission or to submit the matter to the competent authorities for investigation and prosecution. The isolation of COVID or 19, SARS-CoV-2, is questionable. And those that did that, because the UK and none of the countries worldwide were able to issue it as an HCID, a highly infectious disease of consequence or contagious disease, means that Canada committed an international crime. Big time. Now, urgent demands to the Governor General. The Governor General, as the guardian of our Constitution, must swiftly uphold peace, order, and good governance, which is POGG in the government documents. When you look at our Financial Administrations Act and all that, they talk about POGG. Peace, order, and good governance. To safeguard our nation's security, finances, dignity, and prosperity through issuing by formal proclamation. So this is in order to really a demand to the Governor General, because she is liable under the Crown to the people, not to the government, but to the people and the Constitution, to make sure that the government hasn't gone against it or against the people. So her job right now is to issue an immediate proclamation. If she does not do that, then she is guilty of collusion. 1, that our International Bill of Human Rights be immediately acknowledged and enforced by her title and office regarding her duties to the people and this country above governance. To remove the Liberal government. 3, to immediately command that a caretaker government be put in place. 4, to call for an immediate election. 5, enforce the investigations of possible fraud, conflicts of interest, and subverting policy committed by Justin Trudeau, Chrystia Freeland, and other ministers within the Liberal cabinet and parliament. 6, the Governor General should postpone the royal assent of all pending bills until a new Attorney General and Minister of Justice has been appointed, who will uphold our International Bill of Human Rights, the Syracuse Principles, and ensure the constitutionality of the legislation before its enactment, as our International Bill of Human Rights is inherent in the Charter of Rights and Freedoms. To ensure that the bills are void of words that do not conform to the rule of law, which allow a government to manipulate the meaning. And here's an example. Reasonable is found over 2,000 times in the statutes, and that is wrong. These are words that are incapable of any fixed meaning because they denote a quality that is inherently subjective. Paul Salabier. Okay, and there's a whole bunch that Paul gave me that it's ridiculous. And we have to clean up every law that has been created since 1982 and even prior. Urgent demands to parliamentarians and senators to immediately refrain from allowing unconstitutional bills from moving forward and to repeal all unconstitutional bills passed in the last 5 years and previously that infringe upon our International Bill of Human Rights and non-derogation rights binding on Canada and the UK. To review the infringement of these rights, which would also render most of the legislation that has passed through Parliament, the provincial legislatures, and municipal bylaws unconstitutional. to review and rectify all policies and actions undertaken within government agencies, unlawful mandates during the pandemic that infringed on our non-derogable rights, would also render many of the court judgments of the last 4 years in error of national and international law, to review penalties and fines needlessly charged to the public by all levels of governance and policing across the country. 5, to pay attention by reading the UK Hansard statements made by members of the UK Parliament in 1982 in regards to the people's full rights. And 6, to become educated in the entire International Bill of Human Rights before allowing the passing of any bills through Parliament and Senate. This Canadian citizens' referendum is initiated through our legally protected rights ratified by Canada and the United Kingdom from 1948 to 1976. Canadian citizens exercising our collective civil and political rights to self-determination and self-governance within the International Bill of Human Rights. You will find them under all of these documents here that are listed, and you can download all of those. Okay. So we as a people have lost all confidence in our government, parliamentarians, and the provincial legislatures regarding the alleged corruption that has transpired in the malfeasant ignorance of our rights, the rule of law, and misuse of our funds. The Governor General has the full rights to remove Justin Trudeau the minute allegations of corruptions were made. Instead, we were witnessing the full demise of the honor and dignity of the Crown towards their fiduciary duty and responsibility to the people. Therefore, we, the Canadian citizens, find it necessary to move forward with this referendum to remove and replace King Charles III as our head of state, with the Canadian peoples as the collective head of state, corporation sole, and corporation aggregate, represented by an elected Governor General, given the current state of Canadian governance and the persistent misuse of authority, abuse of power, as well as the continued disregard for our fundamental rights. And then they can go and read the ICCPR, the International Covenant on Civil and Political Rights, entry into force the 23rd of March, 1976, in accordance with Article 49. Okay. So the preamble, the state parties to the present covenant, considering that in accordance with the principles proclaimed in the Charter of the United Nations, recognitions of the inherent dignity of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. Recognizing that these rights derive from the inherent dignity of the human person, recognizing that in accordance with the Universal Declaration of Human Rights, the ideal of free human beings enjoying civil and political freedom and freedom from fear and want can only be achieved if conditions are created whereby everyone may enjoy his civil and political rights, as well as his economic, social, and cultural rights. Considering the obligation of states under the Charter of the United Nations to promote universal respect for and observance of human rights and freedoms. Realizing that the individual having duties to other individuals and to the community to which he belongs, is under a responsibility to strive for the promotion and observance of the rights recognized in the present covenant. So agree upon the following articles, Part 1 and Article 1. All peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. 2, all peoples may, for their own ends, together, freely dispose of their natural wealth and resources without prejudice to any obligations arising out of international economic cooperation, based upon the principle of mutual benefit and international law. And in no case may a people be deprived of its own means of subsistence. And this is where we have the right. And then further in the documents, they say that we have the right to take back our natural resources. Okay, so this is really important. Now, 3, the state parties to the present covenant, including those having responsibility for the administration of non-self-governing and trust territories, shall promote the realization of the right of self-determination and shall respect that right in conformity with the provisions of the Charter of the United Nations. This is where the government has responsibility to help us achieve our complete independence and our power as the head of state. Part 2, Article 2. Each state party to the present covenant undertakes to respect and to ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant without distinction of any kind, such as race, color, sex, language, religion, political and other opinion, national or social origin, property, birth, or other status. 2, where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional processes and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. Now, who is liable to this? The ones that are liable is our parliament as a secondary parliament to the Parliament of the United Kingdom. So the United Kingdom is responsible to make sure that the Canadian government finalizes its duty to the people under international law. And if neither does it, that's when we have to step in and go higher. So 3, each state party to the present covenant undertakes to ensure that any person whose rights or freedoms as herein recognized are violated shall have an effective remedy, notwithstanding that the violation has been committed by persons acting in an official capacity. To ensure that any person claiming such a remedy shall have his right thereto determined by competent judicial, administrative, or legislative authorities, or by any other competent authority provided for by the legal system of the state, and to develop the possibilities of judicial remedy. So now that binds the courts to ensure that the competent authorities shall enforce such remedies when granted. And Article 3, the state parties to the present covenant undertakes to ensure the equal rights of men and women to the enjoyment of all civil and political rights set forth in the present covenant. Article 4, in the time of public emergency, which threatens the life of a nation, and the existence of which is officially proclaimed, the states parties to the present covenant may take measures derogating from their obligations under the present covenant to the extent, but it's limited, strictly required by the exigencies of the situation. And it's not forever. It's only for a couple of weeks. Now, provided that such measures are not inconsistent with their other obligations under international law and do not involve discrimination solely on the ground of race, color, sex, language, religion, or social origin. So they are bound by this. Number 2, no derogation from Articles 6, 7, 8, paragraphs 1 and 2, 11, 15, 16, and 18 may be made under this provision, no matter what the emergency, even in times of war. This is what I just added here. Now, 3, any state party to the present covenant availing itself of the right of derogation shall immediately inform the other state parties to the present covenant through the intermediary of the Secretary General of the United Nations of the provisions from which it has derogated and of the reasons by which it was actuated. A further communication shall be made through the same intermediary on the date of which it terminates such derogation. So before they even launch the emergency measures, they had to write or to communicate with the United Nations and all of the countries, letting them know that they were issuing those measures and derogating, removing the human rights of everybody that was at the convoy and across Canada. Article 5, nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein, or at their limitation to a greater extent that is provided for in the present covenant. And 2, there shall be no restriction upon or derogation from any of the fundamental human rights recognized or existing in any state party to the present covenant pursuant to law, conventions, regulations, or custom, on the pretext that the present covenant does not recognize such rights or that it recognizes them to a lesser extent. And this is what Canada is guilty of. They didn't recognize them to a lesser extent. They didn't recognize them at all in regards to our rights in 1982. Now see full document. In the court of public opinion, truth and common sense will prevail. So where do we go to court with this? The court of public opinion. And then once we have that determination, we take it to the high courts. Now, this document is to be forwarded to His Majesty King Charles III, the United Kingdom Imperial Parliament, the Governor General of Canada, provincial lieutenant governors, the Parliament of Canada parliamentarians, the senators, the provincial premiers, the United Nations Human Rights Commission, the Organization of American States, OAS, the International Court of Justice, the International Criminal Court, all United Nations International Bill of Human Rights, Vienna Convention, and the Statutes of Rome signatory countries. So all the countries that signed all of the agreements, which Canada is in breach of, can turn around and sue Canada, the government, for breach of contract. So Nicolas Brassard, CEO, the Canadian People's Union, where you can reach us, and the disclaimer here, the text included therein do not constitute any legal advice from us. The CPU, Canadian People's Union, is a civil and political rights union of Canadian Indigenous peoples, activating their collective and personal rights to personal self-determination and self-governance according to the national and international laws in force, and whose rights are duly protected. Please note that their representative act as researchers only, and that's what we are, as researchers for the truth. Now, to all Canadians, will you sign? Right now we've got 10 signatures because we want to test it out, make sure everything worked fine. But I put it that we need at least 10 million signatures. And now that's in your hands.